Now, why am I mentioning all of this? The influences from the Latin language, the influences from the Normans, the influences from the Scandinavians. Well, all of this causes confusion for the drafters. And indeed, I give you examples. In many leases, the common phrase is, agreement is null and void. Null and void. If something happens. Now the phrase null and void is so common in leases and agreements that most drafters don't even stop to think why they've included both null and void in that same phrase. You see, nullus comes from Latin and void comes from the French. You can pick one of them, you don't need to use both of them. Similarly, I have examples from leases where a tenant is required to observe and perform the covenants of a lease. A very common phrase in many legal documents. The question is there any legal significance or legal difference between observing and performing the covenants of a lease? Most of the time there won't be, but why do we have these two words banded together? Well, observare is Latin to watch, and perfumere comes from the Anglo-Norman. But there is no, generally speaking, legal significance or legal difference between these two terms. Similarly, in leases we have this common phrase, fixtures and fittings are to remain with the landlord following the expiry of the lease, or for example that the tenant is entitled to use the existing fixtures and fittings. But the question is there a difference between fixtures and fittings? Well, fixtures are mostly fittings and fittings are mostly fixtures. So that distinction is not really useful. In property law, the distinction is usually made between fixtures and chattels. Fixture being something that is affixed to the floor or to the ceiling or to the walls, that is included in the lease. Chattels, on the other hand, chairs and things that you can actually lift with your hands. Another example is a lease, for example, where a tenant has the right and liberty to pass over the land. Right and liberty being a phrase that they often use in these types of legal documents. Is there a difference between a right and a liberty? There may be, but right comes from the old English word richt, and liberty comes from Latin word libertas. But what I'm getting at is that you can see that the legal language uses these terms from English, from Old English, from French, from Latin, and sometimes simply we use both words because we're not sure which one to use.